I learned trade dress and trade secrets and introductions to agency law. In an agency relationship, one party known as an agent agrees to represent or act for another party, the principal. Most agency relationships are consensual. They are created when the parties voluntarily consent to the relationship, either verbally or through a formal agreement, expressed or implied. Agency by agreement. Expressed agency is where the principal agrees to allow the agent to act on behalf of the principal. This agreement, known as an expressed agency, is the most common type of agency. A power of attorney is a document that establishes agency relationships. This is a document that gives an agent the authority to sign legal documents on behalf of the principal. Agency by estoppel. When the principal causes a third party to believe that another person is his or her agent, and the third party engages with the supposed agent, the principal cannot later claim that no agency exists. In the business setting, agency is important because it helps define when a business may be bound by agreements made by others. An employer-employee relationship is created when the employer hires an employee to perform a service. Normally, all employees are considered agents of the employer, even if the employee is not authorized to enter agreements on behalf of the employer. Employers often hire independent contractors. These are people that are not employees, but rather hired to perform certain tasks. Independent contractors are not employees because the employer does not have control over the details of the work. Determining whether a worker is an employee or an independent contractor is an important decision because it affects payroll, taxes, liability, and unemployment qualifications. Most importantly, employers are generally liable for the actions of their employees, but not of the independent contractors. Courts are asked to determine whether a worker should be classified as an employee or an independent contractor. In so doing, they primarily look at the amount of control that the employer exercises over the worker. The more control, the more likely that the court will decide that the worker was an employee. Duty of an agent to the principal. An agency relationship is more involved than a typical contractual relationship because an agent is in a position of trust. The agent has an obligation of loyalty to the principal. The duty of loyalty is broad and includes the requirement that agents avoid conflicts of interest and protect the principal's confidential information. Duty of a principal to the agent. When a principal agrees to let another act on his or her behalf, the principal owes certain duties to the agent. If the principal fails to comply with these duties, the agent can bring suit against the principal on contract or tort theories. Because the agent is performing services on behalf of the principal, the agent is entitled to compensation for those services. The contract that created the agency will usually specify how payment is to be made. The contract liability in agency relationship. Principals are classified as disclosed, partially disclosed, or undisclosed. A disclosed principal is one whose identity is known by the third party when the agent entered into the contract. So in authorized acts, when an agent acts within the scope of authority, the principal will normally be required to perform the contractual obligations entered into by the agent. In the meantime, if the agent was acting without authority, the principal is never held liable for the contract terms. In general, the agent will be liable. If the principal is disclosed or partially disclosed, the agent is liable to the third party only if the third party relied on the agency status. If the third party knows that the agent does not have authority, the agent is not personally liable. Tort liability in agency relationship. A principal may be liable for the negligence acts of an agent. The law generally holds the employer liable for the acts of the employee within the scope of employment, even though the employer did nothing wrong. The key in the analysis here is whether or not the agency's negligent act was committed within the scope of employment. Liability for independent contractors' negligence. The general rule is that in the absence of an agency relationship, an independent contractor's negligence does not create liability for the business that hired the independent contractor. This is the summary for the agency law.